So this is an argument to the Supreme Court being presented by John Sauer, Solicitor General of the White House. So he's the lawyer for the White House that argues for the White House to the Supreme Court. It's always the same guy. Brilliant lawyer, brilliant lawyer. Trump is blessed to have this guy. Very gravelly voice. He's interesting to hear an oral argument. Brilliant lawyer. So they're back dealing with the District of Massachusetts court, district court, same court, same judge, who's issued, I'm going to call this case NIH, issued the same kind of injunction against Trump, demanding that Trump keep paying a government bureaucratic agency, except now instead of the Department of Education, as it was in California, in the California decision, now it's the National Institutes of Health instead. This is the parties. I'm going to skip over this. It's the bureaucracy of the National Institutes of Health against Trump. The White House respectfully files this application to freeze the judgments of the United States District Court for the District of Massachusetts. That's an injunction against Trump. In addition, the Solicitor General respectfully requests an immediate administrative stay of this. This application presents a particularly clear case for the Supreme Court to intervene, and this is really important, and stop errant district courts from continuing to disregard the Supreme Court's rulings. This is the heat. John Sauer is no longer talking about this case alone. He's talking about the ongoing abuse and sedition by the errant, unelected, black-robed, tyrannical, inferior district trial federal courts disregarding the Supreme Court's rulings. He's saying, Your Honors, I see it. You see it. It's time for you to do something about it. This is a particularly clear case for this Supreme Court to intervene and stop errant district courts from continuing to disregard this court's rulings. Over 3 months ago, the Supreme Court stayed the district court's order blocking the government from terminating a bunch of discretionary grants. That was Department of Education for California. We just looked at that. This Supreme Court explained that the district court lacked jurisdiction. The first question every court has to ask itself when people come to it with a dispute is question number one: do I even have jurisdiction? Do I have legal authority to hear this case? Because there's lots of disputes, lots of subject matter, lots of geographic jurisdictions over which the federal district courts do not have jurisdiction. So the Supreme Court explained to this district court in California, you don't have jurisdiction to order the payment of money under the Administrative Procedure Act because the APA does not apply to enforce a contractual obligation to pay money. That was the mistaken argument this district court made then, and it's the same one they're making now, even though they've already been corrected by the Supreme Court. Further, this Supreme Court recognized the government suffers irreparable harm because if it's compelled to pay out this money, it can never get the money back. Notwithstanding this Supreme Court's decision in California, the same unelected, black-robed, tyrannical, inferior district federal trial court issued another order, a materially identical order on the same day as the California decision was released by the Supreme Court. The same day, the Supreme Court said, Department of Education, you're stuffed. Your TRO is invalidated. The same day the Supreme Court issued that ruling, the same plaintiffs, again, brought the same APA claims against the government. But this time, instead of the Department of Education, they said they were defending the National Institutes of Health. Because Trump had ordered almost $1 billion in grants, waste, fraud, and abuse that contravened the administrative policy positions on diversity, equity, and inclusion and gender ideology. Just the NIH was spending almost $1 billion on DEI and gender ideology. And Trump said, no, we're not doing that. That's not a policy priority of this administration. That's not the NIH curing cancer. That's DEI and gender ideology. It's progressive fascist Marxist ideology. And we're not going to pay $1 billion of American taxpayer money for it. Listen to some of these programs. The NIH then had to terminate grants to study Buddhism and HIV stigma in Thailand. Not even battling HIV, folks, not the disease. They were battling the stigma of the disease in Thailand in the context of Buddhism. Why are we paying this? How is it in America's national interest to do this? The NIH was paying for intersectional, multi-level, and multi-dimensional structural racism for English and Spanish-speaking populations and anti-racist healing. What the F is anti-racist healing? In nature, to protect telomeres of transitional age BIPOC for health equity. What the F is this? $1 billion of this? We know these were all make-work jobs for women of a certain age and girth who aged out of the dating market and now married Uncle Sam. Grants like these, the NIH explained, rely on artificial and non-scientific categories that are antithetical to the scientific inquiry. So they're not science. They're not science. So Trump said NIH is not going to pay for them. When the government pointed out that the challenges to these grant terminations belong in the Court of Federal Claims, as the Supreme Court just told us in the case of California, from this same district court judge. If you're challenging payment, it has to go to the Court of Federal Claims. The district court doesn't have jurisdiction. So what was the district court's response to the Supreme Court's ruling in California? The Supreme Court's ruling against this judge in California. He said that California, well, it's a somewhat similar case. It's almost identical. The only thing that changed is the name of the federal agency being defunded. Yet the district court, the trial court, dismissed the Supreme Court's ruling as not final and without full precedential force. It agreed with the Supreme Court dissenters, the three, the Sotomayor, the Jackson, and the Kagan, the losing side of California. This district trial court judge gets hit with that SCOTUS reversal, and he says, you know what? I just don't agree with the majority opinion of the Supreme Court. I'm going to go with the losing dissent opinion. And then he says, and in any case, I consider myself bound by the First Circuit Court of Appeals. Which has greater authority, do you imagine, folks? Do you need to know much law to know this? Does the Court of Appeals have more legal authority, or does the Supreme Court have more legal authority? So if the Supreme Court has reversed you, do you get to say, well, you know what? First of all, I really like the dissent in the Supreme Court decision. And second of all, you know, I'd rather go with what the Court of Appeals said and not what the Supreme Court said. Oh my God. This is lawlessness on the part of this judge. This is absolutely impeachable conduct. And then they tried to argue that, well, this is not really a contract claim that belongs in the Court of Federal Claims because we're going to put it under the umbrella of the APA, which the Supreme Court already said is a ruse that they will not accept. So the lower courts required the government to pay out almost $1 billion in grants that the administration considers contrary to its policy objectives. And who's supposed to set policy? Congress, Article 1, and the President, Article 2. Even though forcing the government to keep paying up is the essence of a contractual suit against the government, that Congress barred district courts from adjudicating. They stripped jurisdiction over contract disputes from the federal district courts and gave it to the Court of Claims. And the lower courts came to this conclusion, even though California, the decision, that we just read recognizes that jurisdiction is likely lacking. You don't have the authority here, courts, that the government is irreparably harmed when it's forced to pay out millions of dollars with no guarantee of recouping the money if they win on the merits, and that a freezing of that California TRO was warranted, as we already saw. On top of that, the lower courts held that they could review the NIH allocation of appropriations under the APA. So now the inferior district court is saying, I get to approve, I, a judge, part of the apolitical branch of government, I get to make policy decisions about how the NIH gets its money and spends it. Even though Congress left grant decisions to agency discretion, and the agency, of course, is run by the executive branch. The lower courts deemed those terminations arbitrary and capricious, that's the ruse for the APA, by substituting the court's own political and policy judgments in place of those of the executive branch. Listen to this emotional language the judge here used in its ruling, arguing that the president had set DEI up as some kind of boogeyman. You think boogeyman is a legal term of art, folks? Or is this estrogenic hysteria on the part of the court? That the president had unleashed partisan appointed public officials on an agency with a historical norm of apoliticism. Article 2, folks, is a political branch of government. Article 2 is supposed to be making political decisions. You know who's not? The Article 3 judiciary is not. John Sauer, Solicitor General, writes to the Supreme Court, in every respect, this sequel poses an even bigger affront to bedrock legal principles than did the original. Worse, this case is no outlier. This is an ongoing problem, SCOTUS. District court defiance of this court's decision in California has grown to epidemic proportions. That's a nice use of words when you're talking about the NIH. Epidemic. As the unelected black robed, I'm going to have to email John Sauer. John, you don't just say courts with a lowercase c. These are unelected black robed, tyrannical, inferior federal district trial courts have issued nearly 24 decisions asserting falsely jurisdiction over claims challenging grant or funding terminations since California. Exactly the kind of claims that SCOTUS has already said belongs in the Court of Claims and not in the federal district courts. Other courts properly recognize that SCOTUS precedent vests jurisdiction in the Court of Federal Claims alone. And the result is a sharp conflict between courts that follow this court's rulings and those that do not. Between courts that follow Supreme Court rulings and those that do not. And look at this footnote here. Other rogue courts have issued almost 24. Look at this. Look at this footnote. This is the lawfare against Trump. This is the lawfare, the court's not abiding by Supreme Court precedent. It keeps going. Look at it all. Look at all this is it, folks. This is the seditious conspiracy and insurrection by the unelected black robe tyrannical inferior district trial court judges against the Article 2 executive branch president we elected to carry out our political will. John Sauer continues, for good reason, the Constitution vests the judicial power in one Supreme Court, to which all other federal courts are inferior courts. Now, inferior is not intended as an insult here. That's literally the word in Article 3, Section 1 of the Constitution. They're not Supreme Courts, they're inferior courts. As this Supreme Court explained just yesterday, when lower courts face materially identical injunction requests, this Supreme Court's emergency orders squarely control. They're not preliminary. They have precedential authority. John Sauer points out our judicial system rests on stare decisis, vertical, meaning there's a vertical hierarchy of judicial authority. Supreme Court at the top, inferior Court of Appeals below them, and inferior, unelected, black-robed, tyrannical federal district trial court judges at the bottom. The authority flows downhill. We don't have the Constitution does not provide for a lower court free-for-all. That's not what I wanted to do. Let's try that again. A lower court free-for-all where individual, unelected, black-robed, tyrannical, inferior district trial court judges feel free to elevate their own policy judgments over those of the elected Article II executive branch and their own legal judgments over those of this Supreme Court. This is John Sauer bringing it hard. Hard. There is blood on the nose, or at least there should be, metaphorically speaking, of course. Secret Service. The nose of that unelected, black-robed, tyrannical, inferior district trial court judge. All right, so a lot of this factual stuff I'm going to skip over. It's important for the Supreme Court, but we've basically covered it. It's just all about the cutting off of the funding to the NIH. Some of the programs we were paying for, folks, which is almost $1 billion funding that Trump took away from the NIH. This one we already looked at. Buddhism and HIV stigma in Thailand. Effects of intersectional stigma on HIV prevention among Latino men who have sex with men. Intersectional, multi-level, multidimensional. I guess you have to use the word multi a lot to get $1 billion in funding. Structural racism for English and Spanish-speaking populations. Anti-racist healing in nature to protect telomeres of transitional age. BIPOC for health equity. Controlled puberty in transgender adolescents. You know what that means? That means they have it right here. The role of gender-affirming hormones in transgender women's. The transgender women means men. Men's immune response to COVID-19 vaccines. This transgender adolescence is the gender mutilation, chemical and surgical, of our American children. This is what they want to compel the Article II branch of government to pay $1 billion for. These people are the Dr. Mengeles, writ large, of American society in 2025. There is no punishment too severe for them in the just world. The NIH let everyone know they weren't going to get their money, and so they sued. On April 4th, this court granted a stay pending appeal of a TRO from this court, this district court in Massachusetts, about the termination of Department of Education DEI grants. That's how similar this is. This is the California decision we just read earlier. The Supreme Court explained such claims are likely belong in the Court of Federal Claims, not in federal district court, that the unelected the Supreme Court told this court, the unelected black-robed tyrannical inferior district trial court lacked jurisdiction. You have no authority in these ending the DIA funding cases. That the government faced irreparable harm, and the claimants' monetary damages were not irreparable, so you're not entitled to an injunction. On the eve of this court's ruling in that case, California, with the Department of Education, more plaintiffs from the NIH sought a stop to terminations for DEI in the NIH. We've covered all that already. And the government makes all the same arguments about how all these belong in the Court of Claims. Here's another ruse. I talked about how the APA is being twisted, spindled, and mutilated as an excuse for courts to claim jurisdiction they don't have. Another way they do that is the federal district courts say, well, we have authority under the All Writs Act. The All Writs Act. The All Writs Act says that the federal district trial courts have the authority to issue all writs, all orders necessary for them to exercise their jurisdiction. Sensible. Courts that can't order what's consistent with their jurisdiction would be impotent. So the All Writs Act makes perfect sense. But the way these unelected black-robe tyrannical federal district courts are using the All Writs Act today is absolutely contrary to its clear intent. The All Writs Act does not create jurisdiction. It says where you have jurisdiction, the court has authority to act, to issue orders. But if you don't have jurisdiction in the first place, the All Writs Act cannot save you. It doesn't say you get to issue orders in the absence of jurisdiction. It says you get to issue orders where you have jurisdiction. What these federal courts say is, well, the All Writs Act lets us issue orders whenever we want. That's not what it says. First, you have to demonstrate you have jurisdiction in the first place. These lying, cheating, stealing, unelected black-robe, tyrannical, inferior federal district trial courts. Any of these courts making this argument about the All Writs Act in the absence of jurisdiction absolutely should impeach or remove from the bench for incompetence, for failing to serve during good behavior. So John Sauer argues that the government's likely to succeed on the merits. We don't even need to cover this argument because it's the same argument that was made in the California decision. John Sauer points out the same district that produced the California order from the Supreme Court has again asserted jurisdiction to order the government to continue paying unrecoverable grants contrary to the administration's priorities. That order, if anything, is even more legally flawed than the one this Supreme Court stopped in California decision. As this court held in California, the Tucker Act precludes district court jurisdiction. There is no district court jurisdiction over suits challenging money termination. The district court flouted that decision by declaring that they found the views of the dissenters of the Supreme Court more persuasive. Does a federal district trial court judge get to make that call? Are they not legally bound to obey the majority decision of the Supreme Court and not just say, yeah, I don't like that one, I'm going to go with the dissent, I find it more persuasive? Under our system of vertical hierarchy of legal authority, stare decisis, it's the majority opinion that controls, not the losing dissent. Second, NIH grant decisions are committed to agency discretion by law, not reviewable under the APA. This was all decided in California. Given limited research funding, Congress has appropriated lump sums for the NHA. The challenge decisions were not arbitrary or capricious. The NIH identified, explained, and pursued new funding priorities. That is democracy at work. That's our constitutional order. Not, as the district court claimed, proof of inappropriate partisanship, let alone a permissible basis for setting agency action aside under the APA. I'm going to skip some of this. I did want to focus on some of the histrionic language of this court. Did I skip over that earlier? Let me go up here a bit. I'm going to give a quick look. Here, it looks like some of it. The district court issued its promised written decision holding that the grant terminations were arbitrary and capricious. Look at some of this. Look at some of this histrionic, emotional language being used by a federal district court judge, relying on Justice Ketanji Jackson. Ketanji, I'm not a biologist. How would I know what a woman is? Jackson. Relying on Justice Jackson's California dissent, the losing side of the argument, the court concluded that the NIH had engaged in no reasoned decision-making in the robotic rollout of this grant termination action. All of this is public policy decision-making being engaged in by this court. The NIH decides if it has sufficient reason for its decision. That's not within the purview of an apolitical, supposedly, federal district trial court judge. He does not get to supplant their policy decision-making. He's an Article 3 apolitical judge. Robotic rollout. That's not a term of art, by the way. That's just how this judge feels about it. He doesn't like the NIH's decision, so he's going to characterize it in a derogatory way by calling it robotic. The court objected to the NIH's failure to define the term DEI, which the court found purely circular. We obviously know what DEI is. Every governmental agency and academic institution in America has hired people to run their DEI programs. The thing is, it means different people to different things to different people. But clearly, we know what we're talking about. It's something that actually exists. It's not fabricated. It's incorporated in the grant names that were defunded. More broadly, the court faulted the new administration. Why does this matter? The court calls the Trump administration the new administration. So what? Does a president have less authority in the early weeks of his administration and in the final year? This judge just doesn't like the new administration. Faulted the new administration for breaking a historical norm. It's a historical norm controlling law in America. The judge doesn't like that Trump is changing how things have always been done. We've always had these billion-dollar money laundering operations through the federal bureaucracy. How dare Trump defund that? How dare he disrupt the historical norm of money laundering? What the judge claims, a historical norm of apolitical scientific research. You saw the titles of those grants. Did they sound apolitical to you? Is DEI apolitical? And he didn't like that Trump was weaponizing what should not be weaponized. This could come right out of a Harlequin romance. And I have no idea if this judge is a woman or a gay man. Either way, we should not weaponize what should not be weaponized. What? Who decides something's being weaponized? Stopping paying somebody is weaponizing? And who decides if it shouldn't be done? The court criticized the president's DEI order as rudderless. Is rudderless a term of art? Just more emoting. And setting DEI up as some kind of boogeyman, likes boogeyman, for partisan appointed public officials. Folks, if anyone's supposed to be partisan, it's public officials within the political branches of government. Especially the Article 2 executive. And the court characterized the president's order on gender ideology as a fiat that induced extensive discrimination against everyone whose lived experience of their sexuality is in any way different from the executive orthodoxy. What does this tell you? This tells me the judge has purple hair, at least on the inside. The court described the NIH decision to terminate gender identity grants as a truly hold my beer and watch this moment decision. That's how this judge perceives the Article 2 executive branch president, elected by the whole of the American people to carry out our political will. That's how this judge sees us. What we want in terms of policy, the judge denigrates as a hold my beer, watch this moment decision. This judge believes he's intellectually and morally superior to all of us. That's why I refer to these judges as the unelected, black-robed, tyrannical, inferior federal district trial court judges. They believe they are our betters. And not only should we be bending the knee to them, the man we elect as president ought to bend the knee as if he were a clerk in their court. No respect for our constitutional order, our constitutional republic at all. and that unelected black robe tyrannical inferior district trial court judge viewed the lack of any demonstrable pushback from agency staff as proof of the tremendous bureaucratic pressure at play. This is, first of all, obviously complete speculation on the part of the judge. The court further objected to the NIH reliance on Office of Management and Budget guidance permitting termination to grants that no longer effectuate the program goals or agency priorities, because HHS had not yet adopted that guidance on its own. This is all smoke and mirrors. The court did not dispute that OMB guidance is incorporated by reference into all NIH grants. Given the courts, it's the court, John Sauer points out, that's being arbitrary and capricious, the court declined to resolve respondents' other statutory claims, statutory challenges to the terminations. The government sought a stay from the court appeal the next day, July 3rd. Then they had a whole second case that was incorporated to make one big case. It's all the same nonsense. So I'll skip over much of this. They cover California. We already looked at that. Past California. This is all stuff the Supreme Court already dealt with in a paragraph that should have been binding on this court, but this court didn't like it. This court preferred the dissent in California, the losing side. The Solicitor General respectfully requests that the Supreme Court grant a stay, a freezing of this lower court's order. The district court orally directed the government to reinstate the grants over a month ago. By the way, every federal court knows an oral order is not effective. An oral injunction or TRO is not effective. It has to be in writing. That's why Sauer is mentioning this. More ineptness. Why does a TRO or preliminary injunction have to be in writing? Because if the party does not comply with the TRO or injunction, they can be held in contempt, even criminal contempt, and be put in a cage. So before we impose that risk on them, we require that the order be explicitly in writing so that that party knows exactly what it is they're allowed to do and not to do. There's no ambiguity. We're not going to put people in a cage over ambiguity. So an oral order, an injunction, is without legal effect. And then the court waited over 2 weeks to issue a written decision. And the Court of Appeals then took over 2 weeks after that to deny a stay. Does all this feel like delaying actions? If we can delay Trump another month, it's a month more of our side not dying. Meanwhile, the government's been compelled to restore almost $1 billion of grant money for these DEI progressive fascists to spend, money the government will never see again. Each day, this unelected black robe tyrannical district court's order remains in place. These DEI freaks continue to liquidate that money from the Treasury. Given that the Supreme Court has already addressed the jurisdictional question here, there is no jurisdiction. In a decision, the district court openly defied a stay on that court is warranted. And of course, the Supreme Court should step in and do a lot more to check these judges, as John Sauer alluded to at the start. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.